Haruna Nsibuka, the learned Eunice Aine Mbabazi. We have the learned Juliet Nanteza. Your Honor, we have the learned Norris Ichom. Norris Ichom. Your Honor, we have the learned Zemola Zephania. The learned Jaman Tamtenda. The learned Serum Kuma Faruk. Your Honor, the learned Chigeni Emmanuel. The learned Abubakar Masood. We also have the learned Farida Nakuwa. Abubakar Masood. M-A-S-O-U-D. And the learned Farida Nakuwa. Your Honor, all joint counsel. Joint counsel for the accused persons. All joint counsel for the accused persons, and we shall relate submissions by the learned caregivers, Alex Uganda, yes, and that's how we intend to proceed. But there was, when I saw leave the last time we appeared, we opened application in respect to two applicants. That is S4 and S6. Serum Kuma Edwin and Niaz Yassin. Secondly, we made an application to provide further particulars, specifically letters of introduction will not at hand that day. Which application was granted. We intend to start with that in less 5 minutes. It should be good. You are most obliged, and that will be Apuro or Kato. Yes. Actually, yeah, for the report, we filed. For the report, particulars, maturities, and letters that we refer to were filed, dismissed, and served upon the state. That's why I thought it would take just.
You mentioned only F4 and S7. S7 is good.
No, Nyanzi.
S6
Nyanzi.
I also did notice that there were letters of Sauda Madad.
Yes.
That is F.
That's A9.
For that one, it was other petitions. That's the you oblige permission to start.
Especially for the record, I'm Dr. Singh. And I'm presenting sureties for A4. Edwin. The first one is Rumuma. Please step forward. Step forward. Worship. Rumuma is 49 years. Worship Mark ID is 49 years and is a resident of Namasuba Central Zone in Makinge. Worship is a driver by profession and he drives a special hire in Kampala. He is a father to the accused person. And his contact is 0751 36 7200. The second is Kasekende Joseph. What your ID? Kasekende is 38 years. And is a resident of Namasuba Central Zone in Makinge. Worship is a border rider by occupation. He's a long-time friend and a neighbor. To the accused person. His contact is 0752 47 67 96. Your Worship, we have also provided a copy of the introductory letter for the accused person and his copy of national ID. A6 is a Nyanzi Yasin. I will invite Chiwanka Edward. Please step forward. Chiwanka Edward Chikoso. Chiwanka Edward Chikoso is aged 61 years. Is a resident of Namuranda. In Kajanstown Council. He's a farmer and a landlord who owns houses in Namuranda. And he's an uncle, the accused person. His telephone contact is 0700 38 5300. The second surety is the intensive Joelia. Please come forward. This is 52 years and she's a resident of Namasuba Ward, Masaja in Makinde. Worship, she is a trader by profession and she operates in Ouno Market. She's an auntie to the accused person, and his contact is 0757 18 31 66. Worship. The contact it is 0757 183166. Your Worship, we have also provided an introductory letter for the accused person. Your Worship, we have also...
I hope that time you
Yes,
spent
no, I'm concluding, Your
the
Worship.
day was for organizing yourselves. Okay, it has to organize.
Yeah, Your Worship, I have presented the introductory letter confirming this place of abode. Your Worship, I'm also presenting an introductory letter for A9, which was that is Sauda Madada. Your Worship, we have also explained to the sureties their duties to both this honorable court and the accused people. Your Worship, they abide to be bound by the same. Pray that God finds them substantial and grant the accused people bail as we prayed for.
That closes our case.
Your Honor, this case was adjourned today for prosecution's response to the previous bail application. We intend to submit 10 affidavits in respect of the 10 accused persons. And jointly, we're going to present them, I myself, Sharon, Nambia, and Counsel Bruce Twendire. Counsel Bruce Twendire is going to present the first 3. And then we shall be interchanging.
Can you give us the order for the first 3? Who is the first one, and the second, and the third?
Your Worship. Everyone is Edward Alliance Ebenezer. A2 is Chivumbi Achillel. And A3 is Tassil Calvin alias Bobi Giant. Your Worship, maybe before I respond to the various applications, Your Honor, just a few moments ago, the court was provided with documents in respect to A4, that is from my that is Nyanzi Yasin. And also, Your Worship, the documents that were presented were for the sureties of those 2 applicants. Your Honor, the court was also provided with the introductory letter for A9, that is Southern Matala. Your Worship, we, as the prosecution, and this is on court record, that A6 Nyanzi Yasin had presented two sureties. That is Namhaji Abbas and Nanyanzi Asia. Your Worship, it appears A6 has dropped both sureties. Is that correct?
No.
You're adding most of that. Be that as it may, Your Honor, the prosecution and for A4, Your Honor, he presented only, this was on the 8th of September, he presented only Nachanzi Rahia.
That's the position.
Your Honor, the prosecution, for each of these two applicants, the defense has presented two more sureties. And the court, at the last sitting, granted the prosecution leave to verify the documents as presented by the applicants and the respective sureties. Your Honor, the law envisages as the prosecution phrase, the law envisages time to be granted to the state to verify. Your Honor, this is in the constitutional guidelines. Your Honor, there is also case law from the court of record, Your Honor. We refer the court to the ruling Honorable Justice George Okello, in the High Court of Uganda at Gulu. Your Honor, this is the ruling is criminal miscellaneous application number 4 of 2023. Your Honor, the decision of the court is as recent as the 6th of October 2023. The learned judge, Your Honor, allowed the state, as prayed for, time to verify the details of the sureties that were presented. Your Honor, we pray that the court is inclined to defer, if anything, the state's response in respect to A6 and A6 and A4, Your Honor, for the reasons that we have been ambushed, and we, for all intents and purposes, have to assist the court to reach a decision as to whether these are worthy of granting bail by verification. Your Honor, with that said, Your Honor, that goes also for the introductory letter as presented by A9. With that said, Your Honor, I will quickly refer this honorable court to the affidavits as proponed by the officers of the respondent. We served them on all of them.
We received this today.
Now, this is
Now, actually, as we were here, except for that authority, we need anything from that person.
I've given a copy to your colleague, Counsel Ocheng. Your Worship, we pray that we invite the court to adopt. Your Worship, this submission is in regards to applicant number 1, Segufu Edward Alliance Edinburgh. Your Worship, for housekeeping purposes, we intend to follow the same chronology of the applicants. Your Worship, the affidavit is deponed by Detective ASP Ataife Sarah. Your Worship, the General of Uganda, a detective police officer working under Criminal Investigations Directorate, attached to KMP North. That is according to she is an investigating officer, therefore she is in position or is got capacity to defend this affidavit. You should briefly, under paragraph 3, I don't intend to take all day. The applicant is charged with unlawful drilling, conspiracy to commit a felony. Your Worship, the offense of unlawful drilling attracts a maximum imprisonment term of 7 years. Your Worship, the applicant is charged under 3C, is charged with, among others, a capital offense of aggravated robbery, vice Wangala B 44 of 25, court case number Massacre CO 2793 2024, and he is awaiting trial. Your Honor, the deponent has attached a copy of the charge sheet and committal papers in the case that is before the High Court in Massacre. Your Worship, in that case also, if the applicant to be convicted, he risks to suffer death, which is the maximum. Your Worship, by now, the court may have taken judicial notice of paragraph 4, where one of the prosecution's potential witnesses is on camera and therefore, paragraph 4, for expediency, Your Honor, I will not mention the name, but under paragraph 4, the person indicated therein is a potential prosecution witness. Your Honor, he is on record social media, name it, TV. He appeared on one of the TV stations. He is a colleague and a subordinate of the applicant, and therefore the prosecution's fear is plausible that this applicant is capable of influencing or intimidating or coercing some of the prosecution's witnesses, thereby interfering with investigations. Your Worship, this is a case, the charges with which the applicant is charged is of a serious nature. Investigations under paragraph 6.
Let me have that old woman have a seat. Prisoners, give her seat to herself. That old woman standing.
Worship, some of these cut across all the athletes in opposition to the applications. Several suspects are still at large. There is a real likelihood that the applicant will interfere with investigations should the court be inclined to grant bail. Your Worship, under paragraph 10, under paragraph 9, we note that all the sureties noted by the applicant are younger than the applicant by more than 10 years. And therefore, all the three sureties, there is a huge age difference between themselves and the applicant. Right under paragraph 11, one of the sureties, Ms. Temidisha Sharon, is subject to investigation. Pursuant to section 77C and G of the Registration of Persons Act, Cap 332, Vide Kawempe GEF 90 2025. Worship relating to the offenses related to identification cards. Worship, some of these cut across where some of these sureties are presenting before court particulars of telephone numbers that are not registered in their names. Worship, we have attached on the affidavit the charge sheet in Masaka and the commitment and summary of evidence in that case, and the KYC of the number that was presented by one of the sureties. These were obtained through a court order. As the court will note, they are certified by the issuing telecommunication company. Your Worship, that is it for A1, applicant number 1. I will proceed to applicant number 2. That is Bobi Achileo. Your Honor, without wasting so much of court's time, the Bobi Achileo is a co-accused of applicant number 1 in the case committed in the High Court of Masaka. And both their bail applications in Chivumbi Achileo and 3 others versus Uganda, consolidated criminal bail applications number 15, 16, 17, and 21 of 2025 were dismissed by the High Court at Masaka for, among other reasons, public interest. Your Honor, we will come to that during our submissions, what public interest means in this case. Your Honor, under paragraph 8, the court will have all the time to, but I thought it prudent to also mention that the investigating officer very believes that the applicant's proposed sureties are not substantial to guarantee, under paragraph 8, guarantee the applicant return in court, considering no evidence was laid to prove their authority to compel the applicant. Your Worship, we have availed she states that motion was in public interest. Your Honor, we will submit on why we believe that this is a case of public interest, and we will submit in hope that we shall sway the court to in its reasoning to not grant bail, that this is in fact a case that is of public interest. In its reasoning, Your Honor, to deny these applications, not just for A1 and 2, but we will explain why the prosecution says that this is a case of public interest. Your Honor, I will quickly run to applicant number 3. The applicant is also charged of unlawful reading. A3 is Chassis Calvin, alias Bobi. Your Honor, the charge with which the offense with which the applicant is charged, and the conspiracy to commit the same, is a felony. And in fact, attracts a maximum imprisonment sentence of up to 7 years. Worship, one of the sureties that Worship, in paragraph 4, we note that applicant number 4 paragraph 4. Your Worship, we note that this applicant while giving his police statement, he informed the police that one of his telephone contacts is 0778 22 85 75. Your Honor, he in fact signed that police statement. Your Honor, it is subject to investigations also. Provide however GEF 90 of 2025. Your Honor, why we think this is important, should the court be inclined to grant these applicants for their sureties may be very difficult to trace should the applicants skip bail. And this is synonymous with persons who have the propensity, Your Honor, to engage in dubious or criminal activities. Your Honor, under paragraph 11, the deponent, Detective SP Nwamanya Samuel Pinuzile, states that he verily believes that the applicant's proposed sureties are not substantial to guarantee the applicant's returning to court, considering that no evidence was laid to prove their authority to compel the applicant to attend court should the court be inclined to grant bail. Your Honor, my colleague will proceed with applicant 4, 5, and 6. Most obliged.
For your indulgence. You have 3 sick persons who probably need to start. 6.
This affidavit is sworn in respect of Sarah Kumar Edwin alias Eddie King Kareja. It's deposed by Detective ASP Kateke Sarah, a police officer attached to KMP Law. Your Honor, the applicant now before court stands charged with unlawful drilling.
Those who cannot keep quiet, I'll ask my court orderly to send them out. Let us observe silence in court. Proceed to
The
your
applicant stands charged with the offense of unlawful drilling, which is contrary to section 45(1)(b), and conspiracy to commit a felony contrary to section 363 of the Penal Code. Right, 1 against CRB 131 of 2025. Your Honor, the offense with which the applicant is charged is a felony, and it attracts a maximum imprisonment term of 7 years. Your Honor, the applicant has other pending charges to wit common nuisance, void 1 against CRB 637 of 2025, and a copy of a charge sheet is herein attached onto the affidavit. Your Honor, the state verily believes, as per paragraph 5, that the applicant will abscond once released on bail, since the charges against him are of a serious nature. Your Honor, in addition, in accordance to paragraph 6, the applicant has the capacity to influence the respondent's potential witnesses, that's interfering with witnesses, including one of the witnesses who is mentioned under paragraph 6, who are his peers. Your Honor, Under paragraph 7, we verified the particulars of the applicant's proposed sole surety license rank here. And we obtained a court order to inspect telephone number 075-380-3582 and confirmed that the same is not registered in the surety's name. Attached onto this affidavit is the KYC marked B. Your Honor, pursuant to sections 77C and G of the Registration of Persons Act, Cap 322, the police immediately commenced investigations via Kawempe DF 90 of 2025 into the offences related to identification cards. Your Honor, as we move on to paragraph 9, we verily believe that the applicant's sole proposed surety is not substantial to guarantee the applicant's return to court, considering that no evidence was adduced to prove her role to compel the applicant to attend court as and when they are needed. And Your Honor, like my colleague said, this cuts across the board. Finally, as we discussed on this affidavit, we had before the defense had availed us the national identification and introductory letter. We had included paragraph 11 into the affidavit, but now that the defense has provided, we need time to verify, as my colleague has very cited the law. Therefore, Your Honor, we pray that this court does not grant bail to the applicant. Your Honor, we move on to the affidavit in respect of the Kenge Shari Resort 05. The applicant, Your Honor, stands charged with the offense of unlawful drilling, conspiracy to commit a felony, Bride 1 Degate CRB 131 of 2025. And the offense carries a maximum penalty of 7 years. In respect of this applicant as well, there are pending charges against the applicant, to which a charge of common nuisance, Bride 1 Degate CRB 637 of 2025. Your Honor, attached onto this affidavit is a charge sheet marked A. Your Honor, the prosecution verily believes that their people will abscond once released on bail, given the multiple charges that the applicant faces. In addition, under paragraph 6, there are several suspects who are still at large, and releasing the applicant makes it likely that it interferes with investigations. Your Honor, the investigations are in advanced stages, and therefore there is no likelihood of a substantial delay in the prosecution of this case. Under paragraph 8, Your Honor, the applicant has the capacity to influence the respondent's potential witness named therein. Who is a peer and their colleague. Your Honor, we verily believe that the sureties, the proposed sureties, Sempala Godfrey and Wabire Ismail, are not substantial to guarantee the applicant's returning to court for trial, since no evidence was adduced to prove their authority to compel the applicant, given they are in the same age bracket. We humbly pray that it is just, equitable, and in public interest that the application for bail by the applicant is dismissed as well. Regarding S6, that is Nyanzi Yasin. Your Honor, just like the others, is charged with unlawful drilling and conspiracy to commit a felony. Right under the CRB 131 of 2025. The offense with which the applicant is charged carries a maximum imprisonment term of 7 years. There are pending charges against the applicant, to which common nuisance, right, one day their CRB 637 of 2025. Most copy of charge sheet is here attached onto the affidavit. Your Honor, we verily believe that the applicant will abscond once released on bail, given the multiple charges the applicant faces. There are several suspects still at large. Releasing the applicant makes it likely that he will interfere with investigations. Your Honor, like we said before in the previous affidavit, the investigations are in their advanced stages, and therefore there is no likelihood of a substantial delay in the prosecution of this case. Under paragraph 8, prosecution verily states that, like the rest, this applicant has the capacity to influence witnesses, to interfere with witnesses. For example, that witness therein named under paragraph 8, who is a peer and a colleague. We verily believe that the applicant's proposed sureties, including Namhaji Abbas and Najanzi Aisha, are not substantial to guarantee the applicant's return in court for trial, since no evidence was adduced to prove their authority to compel the applicant. Your Honor, in addition to that, under paragraph 10, in the verification of the particulars of Nanyanzi Asia, the prosecution obtained a court order to inspect telephone number 0775 463 753, which, upon analysis of the KYC, the prosecution established that it was not registered in her name. Attached here too is the court order to inspect that telephone number. The court order, Your Honor, is marked B. Yes, Your Honor. You attached it. You attached the court order marked B.
The affidavit of Nyanzi Yasin?
On the, yes.
Your Worship, if it's not there, it's not in this, and also,
Just for the court of your worship, the defense equally doesn't have the on the promise of this.
I think Your Honor, it was an oversight that we can provide, but we have those court orders.
We can still need to have a rejoinder. Yeah. Yes, this is an additional.
My colleague is working on that. By the time we finish, so that's a way of going. So you're now obtaining this court order because pursuant to section 77C and G of the Registration of Persons Act, Part 322. The police had to commence investigations. Ride Kawempe GF 90 of 2025 in 2 offenses related to identification crimes. We verily believe, Your Honor, that the applicant will abscond once released on bail, since the charges against him are of a serious nature. Your Honor, as we end this affidavit under paragraph 13, Nanyavi Aisia, a biological daughter to the applicant, cannot certainly compel the applicant to attend trial, considering that she's a daughter and younger and dependent on the applicant. Your Honor, we humbly pray that this court dismisses the applicant's bail application as well. Your Honor, my colleague is going to proceed with the next 3 affidavits.
Have you gotten the pen?
Yes, Your Worship, I just think read the information that is here we have here. Thank you, Pastor. Your Worship, A7, yes. A7 is Waisswa, yes. Your Worship, the affidavit in opposition to A7's application for bail is deposed by Detective Superintendent Samuel Attached to KMP. Your Worship, under paragraph 3 states that the applicant is charged with unlawful drilling, the conspiracy to commit felony, by 1 CRB 131, 2025. The offense affects to be convicted to the maximum imprisonment term of 7 years. Your Worship, S7 is also charged, or there are pending charges, Your Honor, against A7 Vide 1 CRB 637 of 2025. Under paragraph 6, it states that there are other suspects that are still at large, and releasing the applicant makes it likely that they will interfere with pending investigations. Under paragraph 7, it states that the investigations and their advanced stages, and therefore there is no likelihood of establish substantial delay. Your Worship, this applicant also presented 2 sureties, that is Mr. Chiza Innocent and Agonge Hidi. Your Worship, however, the applicant through his counsel did not, paragraph 9 is really from the No, he goes on to state that they are not substantial to guarantee the return of the applicant since there was no evidence laid or to prove their authority to compel the applicant. They say it's just equitable in public interest that this application is dismissed. And then paragraph 11 states that it is true and correct to the best of his knowledge, whenever he was born in court. He attaches a copy of the charge sheet indicating the charges with which this applicant is charged. That is A7. Your Honor, I will go to A8. Your Worship, it is sailboat time. I will go. I'll go to paragraph 4. South Uganda alias AIGP Madada. Sorry, beg your pardon. A8, beg your pardon, is Waisswa Mutwe Alex. Your Worship, this applicant is charged with unlawful drilling, conspiracy to commit a felony, Your Worship, and the maximum sentence by CRB 131 of 2025. And the maximum sentence, Your Honor, should this applicant be convicted, the maximum sentence as per the law, that is the Penal Code Act, Chapter 128, the maximum sentence is imprisonment of up to 7 years, Your Honor. Your Honor, under paragraph 5, the deponent states, Detective S. Mwamani and someone dealing with it, he states that the applicant does not qualify as a vulnerable person within the meaning of paragraph 4 of the Constitutional Bail Guidelines for Courts of Judicature, Practice Directions 2022. He goes on to state under paragraph 6 that investigations established that the applicant's spouse, Ms. Katende Ibi, for expediency also, I will refer the court to paragraph 6. And whereas we've not attached, Your Honor, the prosecution has, since the applicant, in fact, the surety would not mind putting it before the public of her ailments, the prosecution, however, decided not to annex it, but rather we are happy to avail the copy to the court. The response of the of the doctor that the applicant told was happy to tell court that we could verify. Your Honor, at this point I will present the response.
You can only join because we are following. If you are not provided.
No, I'm going to provide it. I didn't want to exit because these are public. We're looking for the applicant had said that they were happy for the prosecution to verify whether in fact his spouse was in the medical stage that she told the Supreme Court. Just to save time, I will avail it. It's somewhere down here.
You don't know the document is not attached. So we shall treat it as such.
We're going to provide it. Well, give me a moment, let me find it. I thought it was courteous for us not to annex because, I mean, these are medical records, but we have it. Your Honor, under paragraph 7, that the applicant's attempt to desperately mislead this honorable court that he is a caregiver was intended to obtain a ruling in his favor through deceit and misrepresentation.
For you to qualify paragraph 7, you need the document.
Your Honor, my colleague is fine.
Starting over.
If the court is pleased, I could just take a moment and find it.
So you need to qualify
Most obliged.
paragraph 6 and paragraph 7.
Most obliged.
Otherwise, it will remain here.
Your Worship, but also for thousands of court, the procedure is that if you choose to move by affidavit evidence, then all the evidence you receive. So even procedurally, it is wrong for the document to be smuggled into proceedings, and will object to the same.
You can make it reject. Step Bruce, proceed with your submission.
Your Honor, under paragraph Under paragraph 8, the deponent goes on to state that he verily believes that the applicant's proposed sureties the Chief Magistrate retired, His Worship Baligaya Moses Balimwezo Ronald Msubuka, Honorable, and Ms. Katende Idi are not substantial to guarantee the applicant's returning to court for the following reasons. The reasons are outlined there under. That Baligaya Moses Mufumbiro, being a retired judicial officer, is certainly incapable to compel this applicant for reasons that at a certain age, nature sets in and mobility challenges come into play. Your Honor, Ms. Katende Edith is undergoing medical reviews and therefore may not be the best person to ensure that the applicant complies with the bail terms should the court be inclined to grant the application. Your Honor, the applicant himself presented Ms. Katende Edith as his spouse, and it is on court record. He stated, the applicant through his counsel, that this particular surety suffers from a grave ailment. Your Worship, it is on court record. I don't have to restate it. Your Honor, under paragraph 9, the applicant has the capacity to influence the respondent's known potential witnesses, including person named therein and who is a subordinate. Of the applicant. Your Worship, that under paragraph 11, investigations are in their final stages. There is no likelihood of a substantial delay in the hearing or prosecution of the case. Your Worship, I will at this point go to the deponent is Detective SP Woman Samuel. The applicant under paragraph 3A charged with, among others, unlawful drilling, offences in relation to uniforms, conspiracy to commit the same felony. By 1 Legasera 131, 2025. Which case is underway for the Honorable Police Court. The offence attracts a maximum should the applicant be convicted, a maximum of 7 years. Your Honor, under paragraph 4, the applicant was arrested at Busia Customs border, disguised in dressing, which points to her attempts at fleeing from jurisdiction and evading justice. Your Honor, the deponent has attached a copy of one of the local dailies, that is Nile Post. Your Worship, one of the reputable media outlets. Your Worship, the attachment the heading, Your Honor, that attachment from Nile Post is NUP's Sauda Madada arrested in Busia. Your Honor, the deponent seems to suggest that we implore the court to be moved as such that this particular applicant is a flight. Your Worship, under paragraph 6, investigations are in their advanced stages, and therefore no likelihood of a substantial delay in the prosecution of this case. In paragraph 8, he states that he verily believes that the applicant proposed sureties Zara Luyirika, Serunjoji Emmanuel, His Worship, the Mayor of Kawempe, I guess, and Lukoda Abdul Karim, are not substantial guarantee are returning to court since no evidence was laid to prove their authority to compel the applicant. Your Worship, just now, which we had earlier sought for indulgence, this applicant has presented a copy of her introductory letter. And it states that she is a permanent resident of the village called Nakabuko in Wakiso district.
Excuse me, sir, the one is moving out. That here should be able to respect this place.
But in the verification of the particulars, Your Worship, in verification of the particulars of one of the sureties as presented by the applicant, the court order was obtained to respect telephone number 0775 419483. The general inquiry file was opened by Kawempe DEF 90 of 2025 to investigate the offences related to identification cards pursuant to section 77C and 3 of the Registration of Persons Act.
In the paragraph, did you attach any? Are there any attachments there? Because my copy ends at, I believe this is the Deltos.
Your Worship,
I want to be clear. Is there an attachment?
there should be an attachment, Your
Is
Honor,
there an
but
attachment? So there is none.
most obliged, Your Honor. Your Honor, it is just, equitable, and in public interest that the application is dismissed. This is under paragraph 11. Your Worship, under Your Worship, for the very last applicant, number 10. that is Kaida Doreen. The applicant is charged with the felony to commit unlawful drilling, among other charges, Your Honor. The maximum sentence for the offense of unlawful drilling is 7 years. Your Worship, under paragraph 5, the applicant, or rather the deponent, states that he verily believes that the applicant's proposed sureties, that is Beyond Godfrey, Severu Ali, Barugembe Arnold, are not substantial to guarantee a returning to court for trial, since no evidence was laid to prove their authority to compel her. We invite the court to adopt as it has the other paragraphs. Your Worship, we will make a summary submission in opposition. I was the prosecution has document copies and court record. Prosecution felt it imperative to highlight to court the paragraphs of the various affidavits. Your Worship, maybe before I take leave, I think he was supposed to provide, what was it? There was some 2 documents. Your Worship, second time I'll come back to that. In submission, Your Honor. The defense, rather, in the case of Aganyira Abbott versus Uganda, criminal miscellaneous application number 71 of 2013. The court stated that the onus is on the applicant for bail to present evidence of high value to prove that he will attend court whenever required. The role of the state, it goes on, is limited to casting doubt on the evidence used by the applicant and bring evidence that discredits the evidence of the applicant. The court went on to state that the court does not act on words of mouth by the advocate submitting from the bar, that acts on proven facts. That show the surety has capacity to pay the bonded sum should the court be inclined to grant the application. Worship, it went on to state that the issue for the court was to determine whether the applicant had produced evidence to prove that in fact his sureties were sound. And that this was a matter of fact and also could be proven by documentary evidence. Your Worship, the respondent has made an effort to discredit the application and the grounds fronted by the applicants. In this very authority, Your Honor, that we will avail a copy to the court, states that the evidential value of the LOC letters that are not endorsed by another committee member are but of limited value. Your Worship, this is at page 7 of this authority that we here now avail the court. Your Worship, it goes on that this is to remove the danger of court speculating that the chairperson as an individual knows every human being who resides in his area on a day-to-day basis. Goes on to state that the evidence of the residence of the applicant, how long he has resided in the area, whether permanent or renting, the names of the landlord, would have added value to the application. And that it would have been beneficial to the court if the LOC had included some basic contact details which would make verification easier and in turn add evidential value and contribute to reducing any doubt the court may have as to the correctness of the information contained in the LOC letters. Your Honor, except A9, who has presented a letter of introductory letter from her local area of residence, the rest of the applicants have presented documents that fall short of the holding of the Lady Justice Alpizza Elizabeth Jane, as she then was the High Court, sitting at the High Court of Uganda at Kampala. And we rightly agree with her and invite the court to be swayed towards reasoning before she denied bail to the applicant. Your Worship, this is a High Court decision, and we here now to present a copy to the court. Your Honor, we gave a copy to the defense. At page 7. Your Worship, in the case of Christopher Bobi and two others, the senior's application number 45, number 46, number 47 of 2015. Your Honor, this is a consolidated application ruling, bail ruling. The court expounded on the law on bail and the proceedings. Your Worship, at page 7, Your Worship, this is a decision of the High Court before Lady Judge Margaret Julia. That it should be remembered that bail proceedings are unique or of their own kind. In law, which is sui generis. She went on to state that the state is not obliged to produce evidence in the true sense and not bound by formality. The court may take into account whatever information is placed before it in order to form what is essentially an opinion or value judgment of what an uncertain future holds. It must prognosticate, for that matter. To this, it must necessarily have regard to whatever is placed before it in order to decide the matter. Your Worship, without preempting the rejoinder by the defense, I will still refer you to page 7. It is the law, page 7 of the same authority, for Bobi Christopher and two others versus Uganda, a High Court decision. It is the law that the court is to take the unrebutted averments in an affidavit as unchallenged Your Honor, I will turn to the sureties that Your Worship, I will avail a copy of this decision for my submission, which is why I stated it may be preemptive of the rejoinder. Your Honor, and in the same decision at page 7, the learned judge, as she then was, stated that persons who are in retirement, those doing undefined businesses, not the kind to persuade the court, the High Court then, to grant the orders sought in the bail application. Page 6, Your Honor. The court stated the law as it still is when it was faced with the question as to whether the applicant would stand their trial to the court if the court released them. This is what the court had to say. It is the function of a number of factors which include the gravity of the offences, the likely penalty in the event of conviction, whether or not the applicants have known addresses and tangible interests within the court's jurisdiction, and the quality of the sureties they have furnished. Your Worship, it is the respondent's submission that all the sureties except for Honorable Zahara Yurika and His Worship Serving Judge, the rest had undefined businesses. Your Worship, this very authority traverses this phenomenon of persons who are doing undefined businesses and whether the court should trust them as substantial sureties.
Thank you, Kalisa.
Your Worship, it is also a submission under the law and this very case of Black Christopher, two others versus Uganda. The learned judge states at page 6, Lady Judge Margaret Tikulia states at page 6, that advancement in the age of the sureties and retirement ordinarily comes with issues of reduced mobility and reductions in the income. Your Worship, this submission is in respect to AH, who presented a 63-year-old person standing in surety. Your Worship, he is a retired civil servant and therefore Your Worship decides that this particular surety, in his particulars, he stated that he is an advocate practicing under Alma Advocates.
Associated advocates.
However, there was no proof that was furnished to this honorable court. And I will refer this honorable court to the decision I just cited a few moments ago, where those may be treated as just submissions from the bar. The because there was no such proof of his practice associated advocates. Your Worship, we here now tender a copy of that decision of the High Court, which is a court of record, Your Honor, whose decisions bind the lower bench.
There's a lot of noise, can I have some quiet?
Your Worship, in the very decision again, I beg your pardon, it is the law to check the unrebutted avowings and affidavit as unchallenged. Your Worship, in Christopher Obey again, the court also, in applications of this nature, and again, the decisions of the High Court are binding, the lower bench, that while considering such application, it is noteworthy to consider the seriousness of the offense and the antecedents of the applicants. Your Worship, all but the 9th, or rather the 10th applicant, have other pending charges before other courts. A1 and A2 are undergoing trial phase in the High Court of Masaka, and they have been committed. The same evidence is on court record. The next charge to the affidavit. Your Worship, A4, Serunkuma Edwin, alias Eddie King Kabeja, Lukenge Sharif, beg your pardon, Your Worship, A5, Lukenge Sharif, A6, Nyanzi Yasin, and Kawesi Tony, A7, charged by CRB 637-2025. A case, court case number 1576-2025. Your Honor, before this, the jurisdiction of this court case 1576. Your Worship, and the accused await a copy of the charge which has been annexed, Your Honor, to the affidavit. These applicants await plea-taking, Your Honor.
You mentioned only 8 times. no.
I beg your pardon. I beg your pardon.
And mention A1, A2, A4, A5, A6, and A7.
Your worship, A8,
A3, A6,000,
your worship, A3 and A.
you can excuse me on the question because they help me also make a ruling.
Most obliged, your worship. Your worship, A3, A4, and A9 and A10. I beg your pardon, are the ones that are not currently having other charges outside the charges that are before the Supreme Court. That A1 and 2, they are charged with the capital before Masaka High Court, having been committed. A5, 6, and 7 are charged and await plea taken in Your Honor. I'm not sure if they have taken plea because this court has several other courts around. Your Honor, A8 is also under investigations and his statement has been recorded. That is without prejudice, without appearing to submit for the bar. The rest have multiple charges before this Supreme Court on the same charge. Worship, the question of public interest. Worship, it seems settled by now. Your Honor, I say seems because a number of authorities, High Court, Your Worship, in the case of Christopher Bobi, had this to say. The learned judge, lady judge, had this to say. On the issue of public interest, Article 126 of the Constitution is clear that judicial Article 126 of the Constitution is clear that judicial power shall be exercised in conformity with the law and with the values, norms, and aspirations of the people. Went on to state, while considering bail, the court would need to balance the constitutional rights of the applicant. Your Worship, the emphasis is mine, that is the right to presumption of innocence, the right to liberty, but also the needs of society to be protected from lawlessness. Your Worship, before the court makes a decision on whether or not to grant, it should ask itself, what would a civilian, such as all the applicants, and why? What and why would a civilian be trained or engaged in unlawful drilling, Your Worship, which is the preserve of the armed forces? Your Worship, as the prosecution will ably submit when the day comes in evidence that some of the applicants were in fact robbed, or rather dressed.
What problem is that line of Yes, I would wish to object. There is no evidence before you. No single witness has been presented here. So to make utterances or give evidence from the bar, people are involved in unlawful drilling, those allegations. Unless he has turned himself into a witness, we will be glad to cross-examine him on it. Otherwise, this is bail. They should restrict themselves to a bail application. Those utterances have the effect
I hope some of you, I don't retain you here. Because I don't want you to conduct yourself as if you're on the street. I hope I don't retain you. Just listen. That's all you came to do. Listen, and you go out and finish whatever you want to do. If you want to conduct yourself in an orderly manner, I will retain you. Proceed,
So we are only asking you to refrain the prosecution from taking that dangerous path.
Objection is upheld. The state confine yourself to a bail application. Resist from the evidence that you intend to bring forward.
Most obliged, Your Honor. But I wish to remind my landed brother that applications of this nature are sui generis. Most obliged, Your Honor. Your Worship, on the question of public interest, why would a civilian be trained? I mean, this is the charge. I stand to be corrected, but I'm not going into the evidence.
We are not on trial. We have to cross-examine.
Most obliged, Your Worship. Most obliged. In the case of case of Ojo, Caesar, I've availed the defense a copy of the same. Ojo, Caesar, and the 8 others versus Uganda, criminal miscellaneous application number 4 of 2023. Justice George Okello, sitting at the High Court at Gulu. Stated that the court is supposed to balance the competing rights and interests of an accused with the needs and interests of society at large to prevent and punish crimes committed within its midst. Your Honor, this again brings the question of public interest. Your Honor, the charges that the applicants stand accused of I'm not sure how best I can explain what public interest means. Your Honor, the public interest. Your Honor, the public interest.
Chief, are you ready to move step?
It is obvious.
You're like, no, it's not yet.
It is obvious, Your Honor, that the charges with which the applicants stand charged were not ordinary exercises. And who knows what this would degenerate into if this was not nipped in the bud. Your Honor, will leave that point at that. Now I will go back to Your Honor, this is a copy of the decision I've just cited, which again, as I stated, the law is fairly settled, that the court may take into account factors while considering whether to grant bail, whether an accused will abscond, whether the accused has a fixed place of abode within the court's jurisdiction, whether the accused has sound sureties, and whether there are other charges pending against the accused, the applicants in this court. Your Honor, in that decision, Christopher Brother Aganya, the court was emphatic and on the evidential values of LOC1 letters that are not endorsed by other committee members. But one, Your Worship, the court in fact referred to these as of very limited value. For the one local council committee member couldn't certainly be expected couldn't certainly be expected to know.
Worship, that part, the evidence is in the authority which is lying on has been submitted. We see an attempt to drag, waste time, so that we don't respond. So they have gone into repetition now. So you should control the aspect of time.
Else I'll be seen to do otherwise.
Most obliged, Your Worship.
Was it for emphasis purpose?
Your Worship, I was emphasizing because only A9 has presented a letter with 7 committee members. Your Worship, a copy of the decision, of job.
Will you give any to that?
Yes.
No, Your Honor. It's not on record.
You can present a report since the defense team already has.
They have a copy already.
Present one report. You have? Okay. Then the conclusion statement.
No, Your Worship.
Time is fast spent.
Your Honor, I will make it
By
quick.
standing orders.
I will make it quick, Your Honor.
And I really wanted the defense, I hope the defense team is going to reply. Because I intend to hear you, like if I had done maybe for my own ruling, but not for you.
Your Worship. We pray that we are allowed to
Counsel. Then proceed, we're wasting more time.
Your Honor, I mean, the court was very kind. And Your Worship, we pray that if the court is
What is
pleased,
that one?
that we tender in a plain statement. Your Worship, the defense was, the court was kind to the defense.
No. State, I think, Counsel Uganda, yeah.
That is why you see I shake my hand.
Counsel Uganda had already enlightened us on the law of affidavit evidence. Let us stick to that evidence
Most
because
obliged.
it's what you opted for.
Most obliged, Your
The
Worship.
defense team had opted for oral, you opted for affidavit, now you apply.
Most
the
obliged,
law.
Your Honor. Most obliged. Your Worship will tender in the decision of Waisswa. Will tender in the decision of Your Worship, my colleague will take it up from here.
State Bruce, please, I'm just on the decision of what's what do I conclude?
Your Worship, I will
I leave it hanging?
withdraw that. I so proceed.
Yes, Chief State,
Your Honor,
I hope you don't repeat what
Your Honor,
State Bruce had already submitted on. Proceed,
we
Chief.
are good. Yeah. Your Honor, as a prosecution submitted in respect of the affidavits of A4, A5, and A6, we had submitted to this honorable court that, yes, F4, F5, and S6, the ones I spoke about here, we had informed the honorable court that prosecution had, as mentioned therein in the affidavits, that we had sought court orders, and the honorable court asked, where are they? And we told the court, we have them. And this is, Your Honor, not to smuggle in anything. Before we could attach these documents, we were called before the Chief Magistrate for a meeting. As the Honorable Court will clearly see that the court order is dated 25th September. It's not something we are smuggling in. Therefore, Your Honor, as promised by prosecution, we pray tendering that copy of the court order, and we are ready to avail copy to the defense.
This is our copy, is it?
Yes.
Yes.
And in addition, Your Honor, I would love court to allow me to quote the decision. Please help us with that copy of Ojo. Yes, to substantiate our humble prayer, Your Honor, we would like to quote an authority. Your Honor, yes, Your Honor, we are very well with
We are state.
Yes, Your Honor.
We have materials.
Yes, Your Honor. We were very well equipped. Had it not been for that meeting between the Chief Magistrate and the lawyers. Yes, Your Honor.
Okay, proceed, state. Proceed, Chief State.
Just to substantiate my humble prayer to put in the KYC and the documents pertaining to the Cancer Institute that my colleague had promised, we have them. Your Honor, I quote the authority of
Before you quote the authority, is there an objection to the tendering in defense team?
Your Worship, we reiterate our earlier submission. Alex Bobi. Your Worship, the state chose to proceed under Order 19 by way of affidavit evidence.
yes.
Your Worship, on the 7th of September, month close to, the state was aware that they were going to reply by way of affidavit. Now, the information from the bar, I will not even call it evidence, that the meeting called today at 3 p.m. when we were supposed to be in court at 9, and we have been waiting since morning. A meeting that took 5 minutes. That it is the reason why they have not complied with the law on affidavit evidence. Cannot be sufficient by all standards to allow in smuggling of these documents, because any other mode of allowing would be smuggling in evidence.
Your Honor, the prosecution had not yet finished the prayer before counsel suit because we were still humbly submitting, Your Honor. And just for the court record, we are prosecutors, we are not smugglers. We are not. Your Honor, we seek to quote the authority in that respect. Criminal Miscellaneous Application number 4 of 2023, arising from criminal case number AA211 of 2021. Lawyer CRB 498 of 2021. Ojok Caesar and 9 others. That's Uganda. Your Honor, whereas the defense quoted this authority, it's technically on very different circumstances compared to the circumstances that we have in this case. And this regard, Your Honor, to pray that we avail the KYC that we mentioned there in the affidavit. It was the land judge said justice should not be pinned on technicalities. Your Honor, in this case that we just cited, the defense lawyers made an omnibus bail application in violation of all known laws that talk about bail. Your Honor, that was gravely erroneous in our humble view. That cannot be equated to our humble request, to our humble. That cannot be equated to our humble prayer to have the KYCs that are clearly mentioned in the affidavits. Your Honor, had we not mentioned them, then the defense would say we are inserting new matter. But the KYCs are clearly shown in all the affidavits. So, Your Honor, we humbly pray. And the court asked the state attorney when we were presenting, where are they? And he said we have them. And Your Honor, we pray that the defense's objection to availing them, the court order be overruled, and the court orders be accepted because they form the key in the affidavits. They are the basis of our affidavits. They are a strong component in our affidavits, Your Honor.
Okay, let me give the ruling.
Just on the case cited. We just want to something.
Every time we can't finish, we are being interrupted.
Finish.
Your Honor, the case is a 10-page case. We pray that the defense appreciates it the same way we read it word by word, page by page, not just to pick out a small section and oppose by it. So, Your Honor, we humbly pray that the court overrules the defense as it accepts this key component of our affidavit, the KYC, and the documents from the Cancer Institute that talk about one of the sureties, whom prosecution wants the court to find as not substantial. We wait for that ruling, Your Honor. Thank you.
Yes, but only on respect to the applicability of the authority cited, your job case. Scholarship nowhere in that authority did the presiding judge, nowhere in that authority did the presiding judge hold that the rules of evidence that govern criminal procedure shall not apply to bail applications. And Your Worship, nothing in that authority still, nothing in that job authority still holds that the rules under Order 19 that govern evidence, that govern affidavit evidence are not applicable in bail proceedings. Finally, Your Worship, Chief State made reference to the applications before court against the law, omnibus, something like that. And I would like to submit that we were obligated by this honorable court as case management, since the parties are the same and the applications were coming up on different dates, to have the same consolidated as far as appearances and case management basically.
So just for the record, we are not operating illegally.
Why? Because the state requested for time to verify and prepare affidavits. And I gave time while these people were on remand for the state to prepare and come with organized documents before court. There's no reason for you to come not ready because I offered time. Which some considered illegal, but I offered time for the state to prepare. So there's no reason for you not to come prepared from the time these people appeared on police.
Most of that, Your Honor, as we conclude, it's very difficult, Your Honor, to say we were not prepared when we have the document.
I don't know why they were not attached, because my copy did have them, and neither does the defense copy have them. That's what it
Therefore, pray that all the bail application by all applicants be dismissed by this honorable court. Save for those on whose documents we have to scrutinize and prepare a response, Your Honor. That is in respect of F4 and F6 whose documents were brought to attention just in this meeting, Your Honor. We therefore pray.
You're now going to make a rejoinder.
As regards to the documents of F4 and F6 state, I want to echo to the public that we are embracing the new technologies, that is ICMIS, by the judiciary. It is an initiative for us to access these documents. The defense team managed to drop these documents on ICMIS on the 26th of September. I believe we would have been able to address our minds to them by this time. This is a way that we are trying to cut time and costs for the litigant in all matters, instead of moving forth and back. So I expected that, because this is the way you started this case, was on ICMIS, I expected you to go back and see what is happening. I came here when I knew I have the hard copies already of these very documents. I can present them. I have them. They are here.
Your Honor, they were requested on a weekend. Prosecution does not work on a weekend.
So I'm just putting it across so that in the next future engagements, since we are embracing the system of ICMIS, let us embrace it as a whole, not partially. For your own benefit when you're putting a plea or a charge sheet, but let us embrace it as a whole. For us to conduct our work better, even for the judiciary to run properly.
These documents were, as the court has noted, were uploaded on the 26th. Your Honor, on the 26th, rather the following day, was a weekend. Public offices are not expected to open. For example, even the open weekend, we should have.
I'm not going to prayer, but I'm saying this is to stop the back and forth. We as judiciary are embracing ICMIS. You go back and check for the files. I had the audacity to go and sit and look at those documents myself, so I expected the state to do the same. But for today, I'll give you the leave to go back and
Your Worship, for clarity, having filed the documents, we presented the editor introducing this modification. Yes, we even served them and they said they don't receive notification. That one would be
I'm not going to go deeper, but I'll give the state leave to verify the documents of N4 and S6. But for further management and undergoing litigation before court, I believe we can embrace the new systems that we are trying to embrace as judiciary. Let me have the reply from the defense team.
Space
In
here.
space. Yes, Counsel Evan.
Yes. If I want to submit to you under the Constitution, regardless of the charges the accused persons are facing, each and every one of them enjoys the presumption of innocence. That presumption can only be rebutted through evidence and upon a conviction. You have heard of many charges, this one has charges, massacre, where not heard that any one of them has been convicted. The state is at liberty to ferry and bring charges. Conviction. None of those persons from A1 to A10 is a convict, so that we impeach the character of that person. I submit that you treat them as innocent as the law treats them. Your Worship, a lot has been submitted regarding this bail in opposition. But the principles that govern application for bail are very few. You look at section 75, 77 of the MCA. The considerations are very few. These other side shows don't apply to those sections. You look at them. And I want to invite you.
What are side shows?
Yes? These many things of telephone, plans, those things don't apply.
Yes.
And I will briefly. One of the considerations, is you assess whether they have fixed place of abode. Have you had anything that they don't? All of them. One of the considerations is, do they have fixed? For you to assess whether they will turn up for trial, is whether the accused person or the applicants have a fixed place of abode. Your Worship, I have read it through all the affidavits in opposition. There is no single affidavit assailing the places of abode that are mentioned by this applicant. But as you retire to court to make your ruling, You would also see that in the charge sheet, the places the state is describing as their place of residence. You'll also see in the charge sheet that the places the state described as their places of residence is the exact places where the LCs have written, making that confirmation. Your Worship, the second consideration under the law is you are required to consider the nature of the offense. The nature of the accusations.